I guess maybe I come to speak to you each year because Daryl says increasingly nice things about me. It is rare and unusual that the subject of a talk such as this will dovetail so exquisitely with what we just heard. When Daryl heard and saw the AP release on the FBI agents who cheated on a test, she reacted in her seemingly cynical way, saying, well, really this shouldn't come as a surprise to anybody. And I reacted, what can we do with it? Now, I grant you, we've only had a few hours. And actually, I was doing other things, so I didn't really have 2 hours. But I had a few minutes. And Daryl found a computer so that I could type in the law review office, but guess what? The printer didn't work. So then we sent it to Daryl's computer, and then her computer printed it. And I'll share it with you. You know, I'm going to be talking this afternoon about the specific instructions as illustrations of what you can do and why you should do it. But every once in a while, it's possible to draft an instruction that you just put into a book and hang on to forever. Now, I'm not representing this as one of those great instructions, but you want to have something like it. You want to have something like it, and the law supports it. Daryl and I have argued about the law supporting it. I think we're in agreement that it does. And here's the instruction. We give it next week in a federal court. The jury has heard evidence that some members of the Federal Bureau of Investigation cheated while taking in-service examinations. This evidence was admitted by the court as evidence of the routine practice of that agency and may be considered by the jury whether or not it is corroborated and whether or not the jury heard from eyewitnesses to such cheating. Evidence of a routine practice of cheating by FBI agents may be considered by the jury in weighing the credibility of an FBI agent. A defendant has no burden to prove that an agent acted in conformity with the routine practice of the agency by cheating on an examination. The prosecution has the burden of proving that its FBI agent did not cheat in accordance with the routine practice of his employer. In weighing the evidence in this case, you may, if you wish, consider whether the prosecution has met that burden. That's all. That comes right out of Rule 406. That is habit, routine practice of an organization. The rule says it doesn't need to be corroborated. The rule says there doesn't need to be eyewitness testimony. You've got all you need. As a matter of fact, I think I'd put in the AP wire service under 803.18 and call it a learned treatise. But give them notice in advance. We're going to talk about jury instructions. As I say, very few of them are instructions that apply to every case, or even to more than one case. But let's see how we got into this fix, because we are in a fix. In case you don't remember, law schools don't teach you how to draft jury instructions. And most trial practice courses don't teach you how to draft jury instructions. And And the only way you can learn how to draft them is to try cases with people who know that they're important. But how did we get to this strange mess? Well, in order to understand it, you have to go back before I was practicing law, which may seem an eternity. But in 1936, it was decided that there ought to be pattern instructions. Why was it decided that way? Well, there were a lot of reasons. One reason is that we were getting more and more judges, and the average intelligence of the judges was dropping off steeply. Also, as a corollary to their declining intelligence, and I'm not suggesting that the individual judge became dumber, it was just that the mean intelligence of the judiciary was falling. As a consequence, they really weren't interested, or as interested as they had been in the law. And probably for that reason, the appellate courts were reversing more and more cases based either on jury instructions which were asked for and should have been given, or instructions that were given to which a timely objection had been made. And I was told, I'd never seen the data, but from a reliable source, that before the opinions of the Warren Court emphasized the constitutional parameters of criminal procedure, 50% of all the criminal cases reversed on appeal were reversed on jury instruction issues. So, and to understand what the significance of this is, you have to have been in a court somewhere, as I was once in a court in Erie, Pennsylvania, with an old judge in a complex drug conspiracy case. And I said, Judge, well, I'd like to know what instructions you're going to give the jury. And he said, well, just listen. You'll hear them just like the jury will. And I said, but I have to know what they are so that before you give them, I can make an objection under the rules. It's got to be made before you give your charge to the jury. He said, well, I'm sure the prosecutor will agree that any objections you make after the charge, and indeed even after deliberations, will be considered by the court and by the appellate court as though it was timely made before I gave the charge. He said, now do you have any other problems? And I said, no. And he just sort of sat on the edge of a bench and had some notes in his hand and said to this jury, let me tell you what a conspiracy is. It's not that complicated. These are just lawyers' words. It's a group of people that got together, you know, and they planned and they agreed that they were going to do something that was criminal. In this case, it involved a group of people that said, well, I know what let's do. Let's go out and bring some heroin into the United States. We'll bring it in furniture from Lebanon, from Beirut. And then he went on to talk about a Pinkerton theory of liability for substantive counts, and he went on to discuss the agency theory, and he discussed what these days would be discussed under 801D2E as the co-conspirator exception to the hearsay rule, and he discussed the credibility of witnesses and how ordinarily people who get benefits and are granted immunity, ordinarily those people, their testimony really can't be trusted that much because they're getting so much for their testimony. The government's buying the testimony. But that doesn't mean they're lying. But you really should consider whether the government's, getting what it brought. And on he went. And on he went for almost 2 hours. No, nothing other than notes. No pattern instructions. No instructions that he'd, I think, ever given before. No typewritten instructions. Just a nice old man trying to tell a jury, this is how we'd like you to think about it. Anyhow, that's what judges used to do. And the good judges and the great judges found that that was the single most important part of being a judge, that was the most exciting and the most challenging. If you want to see instructions on, the instructions in Judge Wazanski's opinion, in Darrell will probably correct it, I think it's something like interstate engineering. It's a district court opinion out of Massachusetts, which isn't surprising, that's where he sat as a district judge. What he said was, let's try and figure out what the law is, or what it should be. Should a corporation be responsible for everything that its officers do? Does that make sense? And you read the opinion is the charge to the jury. And it shows you what a brilliant trial judge can do when he just sits there and tries to figure out, this is what the law is, this is what the jury should know, and these are the facts it must find, and this is how you can be fair to everybody. And that's what things were like up until the 1940s, 1950s. By that time, there were pattern instructions. And guess who drafts the pattern instructions? Defense lawyers. They usually put one law professor on the committee, sort of as window dressing. But they have prosecutors and judges who used to be prosecutors. And the instructions, if you've read them, in many cases sound sort of like directed for, a direction to bring in a verdict of guilty. They're anything but fair. The pattern instructions are, first of all, not fair, and second of all, they probably don't have much to do with your case. But they're easy. People accept the pattern instructions. Some lawyers even accept them without reading them. That is, they don't read them over to see whether or not they apply to the case or whether you want them given. And it's outrageous. And we'll come back to some instructions that I've asked for, instructions that have been given when I've requested them, why I requested them, because the only way I can teach you how important it is, and that's what I'm trying to communicate to you. Let's see, I've been doing this, I've been trying cases since 1961. I have never tried a case, not one, in which I didn't draft my own instructions. All right. Because I was taught how to try cases by a brilliant lawyer, actually by 2 brilliant lawyers. One of them was the first major federal case I ever tried, and my wife was a criminal defense lawyer, and I started the case out by trying to figure out how we were going to get some evidence suppressed. It was as a result of the execution of a warrant. And Maury Walsh from Chicago started out by saying, let's try to figure out how we're going to have that jury instructed. And the second time was maybe the second major case, and I tried it with Frank Oliver, and that's where he taught me how to draft jury instructions. But anyhow, we'll get to that case. But let's talk about the patterns. The absolutely outrageous, unread pattern instructions that all of you look at and none of you read. I knew a lawyer in Milwaukee. She was absolutely wonderful. Her father was a lawyer in Indiana. And her father got indicted for fraud, and went to a good friend of his because he didn't have much money, and the good friend agreed to represent him, and he got convicted, and his friend took the appeal, and it was affirmed on appeal in the intermediate court, and then I was asked by his daughter whether there was anything I could do. And I went there, and I appealed to the Indiana Supreme Court, and the appeal was denied. I brought habeas in the state court. Habeas was granted. The state appealed the habeas. The grant of habeas was reversed. I petitioned for cert. It was denied. I went to federal district court, and they said the trial lawyer had waived the issue. I went to the Seventh Circuit. They said the instruction was outrageous, but the issue had been waived. Let me give you the pattern instruction in Indiana, and listen to it. Members of the jury, as you consider the evidence you have heard in this case, you may conclude that some witness testified at this trial in a manner that was contrary to or inconsistent with statements that the witness had given previously. If you find such to be the case, it is affirmative evidence of the defendant's guilt. Okay? That means you can't cross-examine a witness on a prior inconsistent statement, because if you establish the impeachment as evidence of the defendant's guilt, you cross-examine a cop and it's evidence of his guilt. Okay? That had been a pattern instruction for 15 or 20 years. No one had ever objected to it. And no one had objected to it because it said pattern instruction up at the top, and they just don't read it. All right. Pattern instructions, you will find case law in virtually every circuit, the federal circuit. You probably find it in most state courts. That while they generally accept pattern instructions without comment, they will always put in somewhere in the opinion you'll find, of course, we encourage the trial judge to direct his instructions to the evidence in the particular case, and so on and so on. This is just lip service to a concept, but it supports your position if what you want is you want particular instructions. Let's take one category of instruction first. As a general rule, I'm certain that those of you who have tried cases or appealed cases are aware that there is a general caveat that all courts apply. Really, that ties count for the winner. Was the evidence prejudicial? Probably not. Was the evidence of consent overwhelming? No, but it was sufficient. Were the Miranda warnings complete? No, but they communicated basically what the defendant's rights were. Was the search warrant any good? Well, it wasn't any good, but it was close enough for the agent to rely on it, and we'll invoke the Leon exception. Okay. As far as I know, there is only one principle in which ties count for the defendant. And that is when you ask for what is called a theory of defense instruction. I don't know much about state cases. I know that in Wisconsin, a Wisconsin Supreme Court opinion says that the right to a theory of defense instruction is a right guaranteed by the Due Process Clause. But in virtually every federal circuit, courts have held that the defendant has a right to a theory of defense instruction. Look at some of the language. As this concept evolved, look at the language. The defendant is entitled to an instruction presenting to the jury his theory of defense if there is any evidence whatsoever in support of the instruction, regardless of how implausible, how fragile, how inherently unbelievable it is. If there is any evidence whatsoever, the court's failure upon request to give a theory of defense instruction requires reversal of the conviction. It's strong language. And they haven't taken it away from us, at least not yet. Let me give you an example. There was a counterfeiting conspiracy in Chicago. And I established through the government's principal witness, a relative of the defendant, that on one occasion, unrelated to this case, on one occasion he planted counterfeit money in the defendant's car and then gone and been taken before a federal magistrate and they'd gotten a search warrant, but the government learned it was a plant, the government never went any further for it, but it was unrelated to the case in trial. I asked him a question, and that was a couple of years before. And the question was kind of complicated, and Darrell wouldn't have approved, but I sort of slid it by in the middle of a cross. I said, other than that time a couple of years ago in your direct testimony in this case, on any other occasion, have you tried to frame the defendant? No. Okay. That's all. I submitted 151 proposed jury instructions. The court said the defendant was entitled to instruction 11A reversed. Instruction 11A, it is the defendant's theory of this case that he was framed. If the evidence you've heard in support of his theory creates a reasonable doubt in your mind of his guilt, then, as a matter of law, you must find him not guilty. Okay. That's a very simple theory of the case instruction. I have drafted, obviously, much more complex theory. I've drafted theory of the case instructions that go on for 3 single-spaced typewritten pages. Back in the days we had typewriters rather than computers. But the theory of the case instruction can be just that simple. Or, and we'll talk about theory of the case, then we're going to amble on to some other things. I'm sort of keeping my eye on the clock. At least that clock, I think, is telling time. The one over here doesn't seem to be. Now, let's see, how can I do it without spending any inordinate amount of time on it? I get a call from a trial judge, a state trial judge, very bright, very competent trial judge. He's now in the appellate court and is a real prick, but these things happen. Anyhow, he calls and gives me the following sad story. He's got a defendant, he's got a client and a defendant in his court scheduled to go to trial today. This is either the second or third lawyer who's been appointed to represent him. And this lawyer wants to withdraw. And this lawyer is in tears. And he says, I'm terrified of the defendant. I don't care what you do to me, Judge. I'm not going to try this case. I'm not going to defend this man. I don't want to be anywhere near this man. You know, do with me what you must, but I'm not going to try the case, period. And the judge, rather than trying to lock the man up or force him, called me and said, would I take the case? I said, sure. You know, my theory is I want to stay on the good side of judges, even though they probably don't like me very much. So the defendant comes over to my office, and he's as I remember, I think I've got it right, he's a 5-time loser, and I think it was heroin, maybe it was cocaine, I don't remember. And this is his 6th offense, the 5th or 6th offense. And he tells me that he didn't do it, that the drugs were planted on him. They were planted by policemen. The policemen are trying to frame him because he knows that the police are operating a heroin laboratory out in the suburbs, and they're making China white heroin, and the policemen are protecting their heroin operation, and the prosecutor is protecting the policeman, and the police chief is protecting all of them, and they're all in this conspiracy to put this man in prison because he knows about the operation, and he's going to squeal about it, and all of his previous lawyers. He's had 3 previous lawyers, and each of them are part of this conspiracy. I listened to all this. So I said, okay, I tell you what, let's switch sides. You come here behind the desk, I'll get over there. So I did. I said, now I've told you this story, what do you think? He said, I think you're crazy. I said, oh, any special kind of craziness? He says, yeah, I think you're paranoid schizophrenic. I said, oh, why would you say something like that? He says, because you think absolutely everybody is conspiring against you. I said, oh, okay. You got any recommendation? What should I do? He said, I think you ought to go see a shrink. I said, okay. I said, let's change places again. We change places. And I say, now what do you think I'm going to recommend? He said, you're going to recommend I see a shrink, and I'm telling you, go fuck yourself. So we went to try. And I gave an opening statement, much as I just gave it to you. That is, I told him, because I'm going to call him. I got 1 break during the trial. And that was, I subpoenaed, well, I got 2 breaks. I subpoenaed the police chief, because he told me the police chief was part of the conspiracy, police chief of Milwaukee. And the prosecutor took an interlocutory appeal. When the judge refused to quash the subpoena, they took an interlocutory appeal, filing an affidavit that the police chief had never heard of the defendant, knew nothing about him, knew nothing about any of his charges or anything else. And we're now up in the Court of Appeals. During the trial, I'm up in the Court of Appeals. And I got up in the Court of Appeals, I said, you know, a real part of me wants to lose this appeal. And the judge looked at me, the 3-judge panel. They looked, they said, well, why do you want to lose? I said, because, you know, I represent people who they claim are witnesses in criminal cases. If I can get them out of testifying by filing their affidavit that they don't know anything about the case, that's great. They said, no, that's not going to happen. Affirmed. Enforce the subpoena. So we're back down in court. And the police, and I'm cross-examining some witness or doing whatever. Whatever I'm supposed to be doing, I'm doing it. And the police chief calls the judge and wants to know whether I will give the chief 10 minutes warning so he doesn't have to sit outside on the bench waiting for me to call him. As a courtesy, would I give him 10 minutes warning? And the judge, who told me he will never do this again, handed me the telephone. And I've got a telephone in one hand and a jury in the box. And the jury knows that the man on the phone is the police chief. And I'm saying, Chief, I know it's a problem. I really can't do anything about your reputation. You got yourself into this fix and you're going to have to get yourself out. And he is saying, but 10 minutes. And I'm saying, Chief, look, there's absolutely no way for you to avoid it. You have a responsibility to the community as well as to your reputation and honor. And I'm out of the chair. Of course, the judge wants the goddamn telephone and I won't give it to him. So 5 minutes later, I agree that the chief can have his 10 minutes. Chief comes on, I spend 45 minutes qualifying what a chief does. I say, when's the first time you saw the defendant? He said, I never saw him in my life. The defendant, in a voice you could hear across the street, says, you see, I told you he'd say that. Anyhow. Okay. We go to the jury. The judge gives, in substance, the following instruction. Well, I can't repeat it. It's too long to repeat verbatim, but let me give you the gist of it. Members of the jury, ordinarily, when a defendant claims that he's been entrapped, the prosecution and the jury should focus on whether the defendant was predisposed to commit the crime and whether the officers merely presented him with an opportune time to do it and the opportunity to commit it. If he was predisposed to commit the crime, under ordinary circumstances in most cases, the jury will find that he wasn't entrapped. That isn't the kind of entrapment upon which Mr. Shellow relies. There is a second kind of entrapment that is quite rare. And that arises when the conduct of the arresting officers and the police, the law enforcement, is unconscionable. I wish I could define unconscionable for you. I cannot. You are the conscience of the community. If you feel that the conduct of the police in this case was unconscionable, you may acquit the defendant regardless of what other evidence you may have heard. Darrell pointed out to me that she thinks a similar instruction was given in the DeLorean case. I didn't remember it and I didn't know it, but I think it's a good possibility. There are legal scholars who would say that that is contrary to what the Supreme Court has said constitutes entrapment on at least 2 occasions, maybe 3. There are legal scholars who would say the only conceivable support for that instruction is a Third Circuit case that was decided years ago and probably has been overruled. There are some people who think there's a government of the Virgin Islands case that supports it tangentially. But I got it, and it hung the jury. So, that's using essentially a theory of the case approach to a classic and usually unsuccessful defense. But we can use it for other things. We can use jury instructions for things other. Oh, I'll give you a theory of the case instruction. It was a case I tried with Albert Krieger and Oscar Goodwin in Las Vegas. And I submitted 315 proposed jury instructions, and I submitted them for all of the 8 or 10 defendants except one corporation. That is, I drafted them for everybody. Members of the jury, you may have concluded from this evidence that the defendants in this court got together and agreed and conspired to submit fraudulent invoices in the construction of the Aladdin Hotel and Casino for the purpose of defrauding the Central States Teamsters Pension Fund. If you find that to be the case, you must find each of the defendants not guilty, for that is not the conspiracy charged in this indictment. instruction given by Judge Reed. Now, there are those who say he wouldn't give that instruction today. That was his first major criminal case. So I don't know. He also gave a neat instruction that I've asked for again and again, and has been given on a number of occasions. And then as members of the jury, you may have observed during this case that some of the witnesses called by the government were granted immunity. That is, that they claimed that what they would do is they would assert their privilege against compulsory self-incrimination, and the prosecutor asked this court to immunize them, that is, to grant them immunity so that they could not be prosecuted for any such offenses, and the court did so. You may have wondered why certain persons who might have given favorable testimony to the defendants but were similarly concerned, why the defendants didn't ask that they be granted immunity so that they too could testify. The simple answer is Congress did not give the defendants the power to request immunity for its witnesses. That power was only given to the prosecution. And so even if the defendants asked for immunity for one of their witnesses, the court wasn't given the power by Congress to grant it. That may clarify matters for you. And I have asked for that instruction maybe 10 or 15 times after that, and have gotten it maybe half the time. But it has to be a case in which prosecution witnesses get immunity, the defense makes a motion to immunize somebody and cites the case law that the court doesn't have the power to grant it. The court has to not grant it, and now you're in a position to ask it for that instruction. Okay? Well, thank you. Although,
I've been there.
is there, it's just water? You know what W.C. Fields said about drinking water? All of you know that? He says, don't drink water, it's fish fuck in it.
For erotic purposes.
Anyhow, where were we? We were doing something. And you can play, remember, the creative part of the law is in the instructions. All of you have tried cases where the defendant is charged with marijuana. You know, there's only one case in the country that upheld the species defense. And that was reversed by the, that wasn't reversed, but the Court of Appeals in a subsequent case reversed it. That is, one judge entered judgment of acquittal. Said, you know, go ahead, try to appeal that. Anyhow, that, although the species defense is not alive and well in any jurisdiction, and requires a botanist to put it in, even if you could figure out a place to get it, put it. Take a look at the Webster Second International Dictionary definition of marijuana. It's got, its first definition is a plant called Nicotiana glauca. You'll find your statute says that that's not the plant that's marijuana. Plant marijuana, according to your statute, probably is cannabis. You got some analyst who says it's marijuana, and that's all. You're entitled to an instruction. It's got to be this kind of marijuana, not that kind. And you put in the dictionary as a learned treatise, giving them notice in advance that you're doing it. There are so many. And although I grant you the federal law on comparable problems has been now thoroughly screwed up, that is, I established to everybody's satisfaction that there were two kinds of cocaine and only one was illegal. And then when they figured out how to tell those apart, I decided there were 8 kinds of cocaine, and only one of those were illegal. And then states started saying all of the isomers of cocaine are illegal. And Wisconsin's Controlled Substances Board got around and said, we're going to make them all illegal. Shellow's not going to be able to fuck around like this anymore. And so I went to testify before them in opposition to changing the law. And they asked me, why shouldn't we change the law and make all the diastereoisomers of cocaine illegal? I said, because my children haven't gotten through graduate school. They didn't think it was one bit funny. But anyhow, that's still alive and well, depending on your statute. It's not alive and well in federal court. There may be an argument that can be made in federal court in heroin cases. Maybe. It's tougher, it's thinner, and you need a real expert, but there's a possibility. And if your state has done now like Wisconsin has, I don't know how much we want to go into this shit. But anyhow, there are 8 of what are called diastereoisomers of cocaine. But there are hundreds and thousands of regular what are called structural isomers. Structural isomers of cocaine you can buy in drugstores, you can buy in food markets, you buy it, it takes the scent of cat urine out of a rug. There are 700 patents for this shit. And these are the isomers of cocaine. Well, in Wisconsin, just to be on the safe side, they made the possession of an isomer of cocaine a felony. And there are, as I say, 700 things you can buy in a drugstore that are patented. There are isomers of cocaine. But when I raised the issue, they said, we'll reach it the day you have standing. That is the day you say that really your client possessed something that was for taking cat urine out of rugs. Then we'll reach the question of the overbreadth of the statute. But maybe you have courts that are, where some of the members do dope, I don't know. Maybe you can get lucky. Well, let's talk about some other instructions. Maybe some notes of instructions. If I didn't lose the notes, I've got, no, that's not it. Those are the jury instructions. Well, you can, of course, craft serious substantive law by jury instructions. I did it in Wisconsin when I changed Wisconsin's law from McNaughton to the ALI test for mental illness, for criminal responsibility. And that was done on a jury instruction. And well, let me give you another example of the way to play. It rises every once in a while. I talked to the section about it. Let me put it in context. I was trying a general court-martial. The defendant was accused of assaulting a commander or a vessel. And I think he testified it was in self-defense. And on cross-examination, a naval captain who was prosecuting said, "Sailor, this isn't the first time you've assaulted a flag officer, is it?" He said, "Yes, sir. I never assaulted any officer before in my life." And that's where it stood. It stood that way to the end of the court-martial, which wasn't that long thereafter. And I asked for the following instruction and got it. Members of the court-martial, when a lawyer, when a prosecutor asks a question which implies an answer, and the witness does not give that answer, the lawyer who asks the question has the obligation, either one, to apologize to the court-martial board for asking the question and asking that it be withdrawn and its implications be disregarded, or two, following up the answer that was given with impeaching testimony. If a lawyer asks such a question and neither apologizes and withdraws it, nor impeaches it with other evidence, you may consider whether the lawyer asked that question from inexperience or lack of education or inadvertently. If you find that it was for one of those reasons, you probably should draw no inference from it. If the question was asked with the intent of placing before the court-martial evidence which the questioner knew that he could not prove, it is affirmative evidence of the weakness of the prosecution's case. The court-martial board acquitted. 6 months later, I ran into an admiral in the Milwaukee airport. He was on the court-martial board. He came up to me and said, "Mr. Shellow, do you know why we acquitted your client?" And I said, "No, sir." He said, "Let me tell you, that question that he asked, that wasn't a mistake. He was an academy man. They don't make mistakes." When you say academy man, it means he was a graduate of the Naval Academy. All right. I can stay here and talk to you about jury instructions all day long, but I'll open it for questions. Anybody got any questions? It's now 10 minutes to 6. We have 12 minutes of 6. We have 12 minutes to answer. Oh, I know. I have one thing else I want to tell you. One thing else. Those of you who work in offices that have budgets, assuming that there are such things these days, can, if you wish, and I'm not hustling it for it, the name of the organization is Foresight. I think it's spelled F-O-R-E-C-I-T-E. Foresight is a website to which you can subscribe. It is a website for defense lawyers. It has motions. It has briefs. It has oral arguments. It has, I think, statutory interpretation and sections of statutes that have been amended. That's the sort of thing that we have to work with all the time. But it also has a collection of jury instructions that are called the Shellow collection. And that has about, at least I sent them, about 3,000 instructions on their absolute guarantee that they would organize them, because I just had them in case files. And I don't know how many they've organized. They've organized a bunch of them. But some of the instructions I've given, some of the instructions I've asked for, that has instructions I've asked for, instructions that have been rejected, instructions that have been given, and so on. Incidentally, Judge Reed in Las Vegas, Teamster case, I forget, he gave that instruction on the Teamsters, gave, of the 300 instructions I submitted, he gave 60 of them, which is just a phenomenal number of accepted instructions. And afterwards, when we had a party and threw it and all the jurors came, one of the jurors came to me and said, "You know, he gave us those instructions to read, and we read them aloud, and he was telling us we had to acquit the defendants. I said, yes, ma'am. Anyhow, so, in any event, that's one source. Oh, I'll tell you one more war story. I'm out trying a case with Frank Oliver at Bismarck before Judge Devitt. Devitt has written a book on jury instructions, and the first whole 4 or 5 pages or paragraphs or chapters of the book are the powers of a federal judge. And one of the things a federal judge can do, according to the Honorable Edwin J. Devitt, is to marshal the evidence for the jury. We all know what would happen if a judge marshaled the evidence. But anyhow, it's all in there with all the case law that says the judge can impartially and in-depth marshal the evidence. It's a very complicated mail fraud conspiracy. So I asked that the following instruction be given. Frank Oliver says I'm going to get in trouble for it. Things have been going along so beautifully. Nobody's gotten in trouble yet. I can't imagine I'd get in trouble. Anyhow, members of the jury under, and I cite Devitt for this, members of the jury under federal law, I could marshal the evidence for you in depth and impartially. I have not done so. From this, you may neither infer that I understand the evidence nor that I do not understand it. Devitt went right through the roof. Frank was right, I did, yeah. But anyhow, I wasn't held in contempt, but I still thought it was a neat instruction, and I cited Devitt's book for it, for Christ's sake. Anyhow, anybody got questions? Hearing none? Where's Darrell? Has Darrell fled the jurisdiction? Thank you, David Lewis. She's fled. It's been a pleasure having you.